The purpose of a trial is to ascertain the facts and then apply the law to those facts. The jury must know the facts in order to decide between conflicting claims of the plaintiff and the defendant, and to decide what, if any, relief should be granted and what, if any, demand should be awarded to the plaintiff. Pre-trial is that period which precedes the actual trial. Now, during the pre-trial period, both the plaintiff and the defendant are permitted by law to utilize a variety of discovery procedures to investigate the facts. Such pretrial discovery procedures include 1. Written interrogatories, 2. Request for admissions, 3. Request for the production of documents and records, 4. Request for medical examination. But the deposition is probably the most important way to investigate the facts. Here to talk about the deposition is Dr. S. Sandy Sanbar. Now, hopefully to make this discussion more meaningful for you, imagine, if you will, that you're the witness who's going to be deposed, and I shall attempt to ask all the questions on your behalf that you might possibly have. If we can proceed that way, Dr. Sanbar, let's start with the most basic question. What is a deposition?
A deposition is a form of oral testimony which is taken from a witness under oath. This is done not in a courtroom, but conducted in a manner that is approved by the judge. The testimony is taken before a stenographer and is reduced to writing and often used in court during trial. The deposition is a pre-trial discovery procedure, as you indicated in the introduction, and the person whose deposition is being taken is called the deponent.
Okay, I would assume that the attorney that deposes a witness will have a variety of reasons for desiring the oral testimony by deposition. Could you tell me some of the general purposes of a deposition and reasons for taking a deposition?
The general purposes of the deposition are, first, discovery of facts. Depositions are generally taken to obtain information which cannot be obtained through the attorney's investigation or from the client or from other witnesses, and to supplement testimony and evidence that is obtained from other sources. A second purpose of a deposition is impeachment. The deposition serves the purpose of freezing the witness's story. If the deponent later testifies at the time of trial in any way differently from his testimony at the deposition, his deposition would be used at trial for the purpose of contradicting and embarrassing him or her by showing prior inconsistent statements. This is called impeachment. Juries are inclined not to believe witnesses who change their stories. A third purpose of a deposition is admissions which would constitute affirmative evidence. The examining attorney may try to trap the deponent into admitting facts which will hurt his or her case, or trap the deponent into inadvertently misrepresenting the facts in a way which would appear to the jury as if he were not telling the truth. A fourth purpose is preservation of testimony of a witness. A witness or a party who, for one reason or another, might not be available at the time of trial can be deposed, and the transcript of the testimony may later be used at trial if the deponent cannot appear to testify at trial. A fifth purpose is learning the identity of the witnesses. The examining attorney may require the deponent to state the names and identities of other individuals that may be witnesses to the particular occurrence or who may have other information which might be useful. This information may lead to further investigation and further depositions. Now, there are other reasons, including narrowing and clarification of the facts and issues, providing an opportunity for the client to learn about the opponent's side of the case, and evaluating the case for settlement. In most instances, those cases which ultimately are settled cannot be properly evaluated for settlement until attorneys on both sides have completed taking depositions. The taking of the deposition is often a convenient opportunity for counsel to discuss the possibility of settlement.
I'm getting from what you've said so far, then, that there is a difference between a deposition and a trial. Am I correct in assuming that? And how should a witness then prepare for a deposition?
Yes, there is a difference between the deposition and the trial. Deposition is a one-sided affair which favors the examining party. The deponent is under a general obligation to answer all questions, and he will be asked questions which may not be admissible in court. This is to allow discovery and pretrial preparation. The judge will not be present, and the attorney will play a very effective role. It is critical that one should remember that the attorney on his side will be listening carefully and will object to improper questions. Don't misconstrue the silence as failure to protect your interests. Your attorney, say, will hold a pre-deposition conference, and before attending that conference, the witness should painstakingly and thoroughly review the entire history of the incident that provoked the lawsuit. Prepare as if you are going to be deposed and carefully review all documents pertaining to the case. The attorney will want to advise you about the tougher questions that you would be asked, and he may want to practice a dry run as if it's a deposition and he would be the opposing counsel.
Okay. This may seem very basic, but it would help me to know, where is the deposition taken? Where would that be conducted, and who'd be present?
It may be in the office of the examining attorney, or it may be in the doctor's or nurse's office, and it is informal. Usually the witness, the counsels on both sides, and the stenographer are present. The plaintiff may attend, but rarely does. The examining attorney may be actually very friendly, but don't be lulled to sleep. This cordial atmosphere is often created so that you would be more likely to talk freely. The law office is as alien to the doctor as the practice of medicine is to the lawyer. It's a strange environment, and one feels anxious. Try to realize that despite the importance of the deposition to all concerned, it is a routine setting for everyone but you. Try not to be nervous.
That could be difficult. You know, one of the things as I sit here and think of is, as a healthcare provider, I'm unfamiliar with the adversary system. It's you know, it's not my domain.
It's true, and that applies to all non-lawyers. But still, do not be upset if your lawyer chats with opposing counsel. They may be quite friendly, and this won't work to your disadvantage. When the parties are ready, the parties may agree to certain stipulations. These generally concern stipulations such as notice, filing, certifying, signing, etc. They are technicalities. They have no great significance to the witness. The lawyer may explain them to you if you desire. Generally, these are entire to streamline the deposition process. And the most important stipulation is that objections about the substantive aspects may be reserved until trial time. After stipulations are made, then the witness will be administered the oath.
Okay, then I presume that the attorney commences to ask questions of the witness. Comes next. Would you give me some pointers about the conduct of a witness during this deposition?
Well, first, it's the way in which the answers are answered. Here are some pointers. First, do not answer a question until you understand it. If the question is unclear, ask the examining attorney to repeat or rephrase it in a language that you can understand. The stenographer may be asked to repeat the question too. Second, think about each question before answering it. Do not supply information that is not requested in the question, even though you may think it's relevant. If the examining counsel does not ask you about information, do not volunteer it. Also, if you do not know an answer to a question, say you don't know. Do not feel that just because a question is asked, you are expected to know the answer to it. Do not guess or assume. Give factual information in answer to a question, and only if you have first-hand knowledge. Do not base your answer upon so-called hearsay information, that is, something that someone said to you, unless you are specifically asked for hearsay information. And if asked, Do not hide any facts from which you are specifically asked unless you are instructed not to answer that question. If an objection is made by your counsel, stop speaking. And if you're instructed not to answer a question, do not answer it. Unless your lawyer makes an objection and instructs you not to answer, you must assume that you are bound to answer if you know the answer to that question. And avoid asking questions in your answer unless you are asked for a clarification. Only the examining attorney can ask questions. Do not try to memorize your answers. Give a factual, straightforward response to the question. And if the question of fact is asked, make it a practice to check it against any records that you may have, even though you may be sure of the answer, and then answer it briefly.
Dr. Sanbar, I'm a very visual person, so I'm trying to get a picture of what we're doing here. Tell me about things like dress, speech, manners, demeanor, and honesty of the witness.
One should dress according to his style, dress well, to be courteous and exercise good manners. Now, the opposing attorney, remember, will be evaluating the witness. From the very moment that witness comes, he must remember that he should take great care in his or her appearance and remarks at all times. This will show the examining witness that you would impress the jury. Don't look for traps in every question. There are not too many trick questions, and if one comes along, your counsel will try to help you and tell you about it. Don't argue with opposing counsel, and don't get angry or hostile. Don't get emotional. The opposing attorney may be deliberately trying to provoke you. Speak up so everybody can hear you. And keep your hands away from your mouth. Answer each question with a verbal response. Remember, the stenographer is writing and cannot take down shrugs or nods. The law requires only that you testify according to your best memory. If you are uncertain about an answer, indicate this uncertainty in your response, and if you have no memory whatsoever on a particular point, say so. Do not guess or assume what you now think must have happened. And don't be afraid that you have had conferences with your attorney. Every good lawyer has conference with his client. If the examining attorney asks you, did your lawyer tell you what to say at this deposition? You should answer, my lawyer told me to tell the truth. You can be required to give a simple yes or no answer to a proper question, but you will always have an opportunity to explain your answer if it needs explanation. If opposing counsel cuts you during an explanation, you should state that you have not finished your answer, so your counsel would ask you to amplify during his cross-examination. And finally, try to fight against showing exasperation or fatigue, even though the questioning may be very extensive. You will be protected against unwarranted harassment by your counsel. Let your counsel know, however, if you feel ill or overly tired during the course of the examination. He can arrange for a short break if necessary, or even adjourn until another day.
Dr. Sanbar, I think I need to know a little bit more about the examining or questioning attorney and what kind of questions to expect.
As we mentioned earlier, the examining counsel may have several reasons for taking the deposition. The form of his question reveals his major interest. If the questions are primarily for discovery purposes, the questions will be broad and the subject far-reaching. This will encourage rambling answers which might reveal new facts. If the questions are sharp and short, then the deposition is being conducted to produce admissible evidence, testimony which the judge may allow to hear at trial. When the examiner is trying to compile admissible evidence, he will also try to freeze your testimony. He will repeatedly ask, was there anything else, doctor? Or have you told us everything? He forces you to commit yourself in a position that you cannot amend or correct at the time of the trial without risking impeachment. examining counsel may ask many leading questions. A leading question is really a statement of fact which contains the answer and only asks the witness to agree. Counsel is asking you to answer yes to his statement of facts. He will try to put words in your mouth. If any part of the leading question is incorrect, you should not answer yes, but make clear by your answer that you cannot entirely agree. Most examiners like to proceed in a linear or chronological fashion. But when the examiner discovers a new fact, he will probably pursue it all the way and only then return to his outline. So the examiner will try to get responsive answers and will ask the question in several ways until he gets a response. And he will demand accuracy to the limit that you can provide. He will be very watchful for prior inconsistent statements, but he may not tell you when he finds them.
What about the pitfall question?
Pitfall questions, you know, the examining counsel is trying to create the view that you have understood the deposition and would like to protect himself that you are not saying things that because you did not understand the meaning of the deposition. It is not possible to predict what questions the witness will be asked and what order, but as a rule the first few questions would seem incidental. Your name, family, practice, address, where you practice medicine. But the first major series of questions would focus on the education, from college to post-specialty training. It is possible that the examiner will go into very great detail in this matter. At some point early in the deposition, the examining attorney will begin a meticulous, often redundant and exhaustive inquiry into events that led to the lawsuit. No detail is too small for his concerns, and some of the questions may not be relevant. Not all will be relevant, and not all even will be intelligent.
I understand from other people that I've talked to that there's some questions for which you need to be especially wary. Could you talk about that a little bit?
Yes. Well, often, you know, we are talking about a long-term treatment of a patient. So one would need to know about the whole history, know the chronology, be sensitive to the questions of facts that led to the treatment under review. Now, questions that focus on what the patient did and how you communicated, and most importantly, what was not communicated. The counsel would ask, say during surgery, you informed the patient about certain risks associated with the specific operation. And he may ask if you were aware of certain risks. Questions about pre-treatment. The witness may be asked if you consulted textbooks or journals or other doctors about the condition. Questions about the extent of the knowledge of a particular medical situation that caused this situation to arise. Then watch for consulting medical treatises. The concern is that the more you tell the examining counsel, the more you help him or her. One of the toughest problems is to get an expert witness. And if one tells the attorney a lot, then it is possible that by giving him that knowledge, he would have knowledge that he's unaware of. Now, watch out for questions that you might divulge too much. You may be asked a question, tell us everything you know about this story. So keep your answers accurate, brief, and truthful. Then another pitfall is the hypothetical question. There are many questions where the physician would have difficulty answering to his or her satisfaction, and the toughest are those in which the examining attorney asks you to assume certain facts. Often he's using such questions to try to trap you into becoming an expert witness for the plaintiff against yourself. And the classic situation, let me finish, is where the plaintiff's attorney asks the defendant doctor if he would agree and if it is, say, contrary to the practice. And here we can talk about the, say, the question of appendicitis. The doctor would be asked if the patient had, say, the 12 classical symptoms of appendicitis. Now, the doctor may not agree, and the plaintiff's attorney would require an answer based upon a hypothetical question. Now, assuming that the plaintiff did have these symptoms, the plaintiff's attorney would ask, is it bad practice not to hospitalize the patient? If the doctor agrees, he has then become the plaintiff's expert against himself, because the plaintiff patient will go on to testify that she or he had the classical symptoms, and the expert testimony necessary to get the case to the jury will have been supplied by the defendant. If the doctor had not become his own expert against himself, assuming no other expert testimony, he would have won the case on a directed verdict.
How then does one try to avoid becoming an expert for the plaintiff's attorney?
There are a number of ways to try to avoid becoming an expert for the plaintiff's attorney. The first line of defense might be to ask for more facts. The hypothetical question presented, it may not be complete enough for the defendant to give an opinion. The final back-to-the-wall situation is for the doctor to say he never treats hypothetical patients and he cannot give an opinion unless he actually physically examines the patient. If the doctor states he has no opinion, that is the end of the matter. Although the doctor may run the risk of looking unsophisticated in front of the jury, he may have saved his case.
How much, I guess, detail can you expect the examining attorney to get into during the deposition?
Well, prior to the deposition, the plaintiff's attorney may obtain a long statement of every statement that was involved in the medical care from the client and everything that was said during the care of his or her, the client. Now the doctor will be asked to give a similar statement and would try to compare that story of the doctor versus the story of the client. So the doctor would be asked, or nurse, to say everything that anyone said about the case. One may be asked to trace every step of care of that individual and would be asked about day-to-day, visit by visit, from the first visit to the last. You can be completely committed on every point as to exactly what you did and did not do, so that later you cannot change the story. You may be asked if you have been involved in other litigation of this kind, and this may be later the basis of impeachment if unresponsive answers are given.
Often, it's my understanding that a plaintiff's attorney will ask a why question during the deposition. Is this also common practice during the trial?
During the actual course of a trial, most attorneys never ask the question why. The reason is there may be fear to allow the witness to make a speech that may destroy the counsel's case. But no such reason is valid in the course of an oral deposition. If the whys of medical treatment are going to beat the plaintiff in the courtroom, the plaintiff's attorney may very well want to know about them before going through the expense of the trial. The plaintiff's attorney knows that the defense attorney is going to dwell on those subject matters during trial. So the why questions during deposition would not prove so disconcerting as in an actual trial for the plaintiff's case. Why a procedure was done, why a particular mode of treatment was instituted, or why this was or was not changed, why not this drug, why not that. And in a drug reaction, for example, inquiry may be made as to the precautions and complications and warnings about the drug and its use, and what was done when the reaction occurred, and why was the drug prescribed in the first place.
Okay, if you can be a little more lawyer Sanbar than Dr. Sanbar right now, let me ask you, if you were the deposing attorney, what questions would you ask a witness or an opponent, a case where the doctor, let's say, misdiagnosed a patient's ailment and then prescribed an ineffectual drug to treat it?
Well, I hope you will appreciate that any attempt at illustrating such questions will be oversimplified. Okay. Under the circumstances where the doctor misdiagnosed the patient's ailment and then prescribed a medication which was ineffectual in treating it, the deposition examination of the doctor could very well proceed in this manner. Now, doctor, did you take a history in this case? What was the history given you? What significant factors did you find on physical examination? Based on the history given you and your physical examination of your patient, did you diagnose the ailment or condition from which the patient was suffering? What was your diagnosis? Why was that your diagnosis? What other factors were present which could have then led you to a different diagnosis? Did you rule out this or that diagnosis? Why did you rule it out or decide against it? What course of treatment did you decide upon? Why did you decide upon that course of treatment? What drugs did you prescribe in treating this patient? Why did you prescribe the drugs? And so on.
Okay, let me ask this finally. If I were the witness, I think I'd kind of like to ask you what protection and objections are provided on my behalf by my attorney.
Your attorney has a right to advise you not to answer questions which he or she believe are improper. That right is exercised sparingly. If he hears a question for which you are not prepared and which could harm your case, he may instruct you not to answer it even at the risk of judicial sanction. However, this is only used as a very last resort, because refusal to answer the question gives the deponent counsel the right to adjourn the deposition and try to get a court order requiring you to give an answer. Naturally, your attorney will object only under the most extreme circumstances. Privileged matters, that is, communications between a lawyer and his or her client, are beyond the scope of oral deposition examination. Irrelevant matters are also outside the scope, but discovery rules make the scope so broad that it is sometimes difficult to tell when something is irrelevant. The test of admissibility at a deposition is only whether the inquiry might lead to admissible evidence. But counsel will try to resolve disagreements of these questions, and often they will reword or rephrase any question and reach a compromise. It is important for you to remember that your attorney may object only to very few questions, possibly none whatsoever. But do not misconstrue his silence. The deposition proceeding is primarily for the benefit of the examining counsel, and it's only when there is a grossly improper or irrelevant question that your attorney will object to the question. On some occasions, he may object to the form of the question. This may lead to examining counsel to withdraw and reformulate the question.
Thank you, Dr. Sanbar. Obviously, it's a position that as healthcare providers, most of us don't want to wind up in. And as I've tried to imagine questions you may have wanted to ask, I'm afraid I've left out some. But what I do hope is that you have a clearer picture, as I do now, about what will happen during this proceeding. We once again hope this is very helpful to you.